fuck out of here. Let's get the fuck out of here, basically. Type, you know how Lang is. He doesn't want to
Yep.
waste his time. Everybody plead guilty. They even threw Speedy under the bus and said you were there. You were in, like, went on the stand and said Speedy was there because Speedy was trying to say he wasn't there, didn't kill Jimbo, blah. They threw their own man under the bus and they still didn't get the full charges because that was the focus and not going over and discussing the evidence and our witnesses. So it wasn't articulated enough to get the charges they wanted. Gray is livid. Oxby is livid. Gray doesn't even know if he wants to do court shit anymore over it. Like, they are fucking pissed.
What did they lack in terms of articulation though?
They would have a witness up there to explain the chain of events and how these suspects directly contributed to the death of an officer. And as they're going through the series of events, there was objections from the Babylonians that, we already pled guilty to this. We don't need to hear this shit.
They
the judge was like, okay, yeah, we don't need this.
And so,
well, did a judge
heard Falconer say he didn't even get to look at everything, something like that, when we were at the prison when they were doing the thing. He said that he had to, go skim over everything. I think he said he couldn't go through everything in detail because of everybody pleading guilty, so he didn't look at the case the same, which is could kind of be a mistrial in my opinion, just from hearing that from him, right?
That sounds like mistrial territory.
So the defense essentially kind of pushed the result. I don't really understand what happened.
They just wanted to press fast forward and go back to jail, and so they go back to their home. In doing that, our side didn't get to articulate the evidence. Therefore, Falconer, when he went, he listened to interrogation, but it was like they all pled guilty already. So they didn't get the charge that they pushed because they didn't get to articulate it. They just highlighted the evidence.
Is that not on the
Hold
judge?
on. Who was the attorney for?
No one.
They didn't have an attorney, and they still.
Hold on. Wait. None of them should have been able to object then, right? If they pled guilty, they're out of they're no longer involved. If they pled guilty from the start, why were any of them? I mean, I understand why they were there physically,
but
why
to the closing? And Oxby had to put it in their terms because they were like, your words are too big. So then he's like, you guys did that shit or something.
It was almost like a Littleman case. Like, that's how it went. Like, every disregard for proper protocol, everything was thrown out.
Yes. And your girl here, thank you, made sure that we got money from the sheriff, by the way, because when you process people at the up north, we don't get the money. They get the money.
Yeah.
So four of them got processed for this. And I spoke with the sheriff and he already refunded the money to us, 1.2 million yesterday. So if any of them get released today, I have to go back and look. If they get billed at the prison, that money needs to be sent from the sheriff's office as well. He's already agreed, no issue. So we don't have to bring them back to LSPD because again, yesterday was a fucking shit show.
Okay. Sounds like it.
Oxby and Gray were like, I don't care about the money. I'm like, I do. The work that you put in, and our department, it needs to go back to the department so that you guys can have things you need to continue. Period. Like that's what I. Yeah.
They just gave up because they're just defeated.
Upset, and I know that, and that's what I told them. I said, "Don't worry, I got this." So that's why I dealt with the money stuff.
Okay.
It was such a huge slap in the face.
What was the actual objection? Like, what they went. Objection.
There was multiple.
Objection. We already pled guilty to this shit. We don't need to hear it.
Yep.
Who was the attorney?
There was no attorney.
Lang was like most.
That's what I'm saying. Unless any of them were bar certified, like they shouldn't have even been allowed to.
Yeah.
They pled guilty. They're not. Here's my issue with that whole thing. Let's assume they didn't plead guilty, and a party on their side decided, you know what, I'm going to be the attorney, and then it went drastically wrong. Are they going to try to claim
mistrial because they didn't have proper representation?
Exactly. Like that's a rough one. That's very rough.
It was horrible. And there's no reason that
3 minutes to
they
meeting?
couldn't have took time to review the evidence and acknowledge the guilty pleas because it was scheduled for 2 days. They did not have to speed run it in 1 day.
I did bring this up, by the way. I did say that if we go overboard with any potential plea deals, alternatively, if we don't offer them a plea deal, there's going to be all this scheduling for a court case where they're going to show up and just plead guilty in front of the judge, and it's going to be entirely up to the judges as to what the consequences.
That was another objection during opening was why weren't we offered a plea deal?
Oh yeah.
I told Pred specifically that it is entirely out of our hands. It would be no different than us having a suspect in the cells that we're saying, "Hey, bud, sorry, you were a dick. You didn't want to work with us full time." And they go, "Well, hold on, bench trial." We go to the courthouse with them, and the judge goes, reckless evading, robbery of a high security, resisting, class 2. How do you plead? And they go guilty. We're not rehashing all the facts again. Like at that moment, well, not in that moment, but it'll eventually be determined what their time and fine is, and that's that. And it'll be entirely by the judge, with no input from us. That is their job at that moment. I think we should have. Again, I'm not of the mindset that like we needed to be incredibly lenient, but if we didn't offer it at all, I think we were shooting ourselves in the foot there. Because then it's left entirely to the judge, which would be the same person, by the way, who would have to approve our guilty pleas to begin with. So like realistically, there's a floor that we never would have been able to go beneath because a judge would just say, no, that's not appropriate.
What so I just don't understand, like an officer died, you know?
Yeah.
Barrett's on his way, Maxwell.
Oh,
yeah.
well, we'll have to talk after the meeting. Unfortunately, it's meeting time.
Oh.
Yeah, tell him we'll meet after the meeting if that works.
Okay.
Yeah, and they were saying we did that shit, by the way. And like when they walked in, so you know.
Okay.
They
Wait, so
him,
what
but...
was they got time served and they get fined or
time served starting from their bail stuff.
Oh, the bail shit. Okay.
So,
you guys see me moving?
Why'd you shoot me?
No,
I haven't
no,
shot
did you
anyone.
Shoot me?
No.
Who shot me?
I'm shooting the eggplant because I care.
Wait, the eggplant. Wait, who's eggplant?
Above the casino. Or not the casino, the slot, sorry. I shot no one. See, I'm a good person. What a tea-filled day. So says it has been 1.5 months since the verdict was rendered, and Miss Mayberry is still waiting to be compensated for the violation of her rights by the LSPD. We understand that there is still a judicial appeal pending, but civil action verdicts are usually paid regardless of any suggestion or threat of judicial appeal. May we please have an update? That was October 29th, and on October 28th, they posted on the judicial appeal saying, while we wait to see if a justice picks up this appeal, can Judge Ma please order the LSPD to pay my client the relief awarded in the initial verdict. It has been 1.5 months since the verdict was rendered. Ms. Mayberry has waited patiently in limbo for the appeal to be approved or denied or to be compensated for the violation of her rights. No, we absolutely do need to pay this. roll. Judge Moss submitted a written verdict for Mayberry versus Frost and Maxwell. In this verdict, the judge failed to consider crucial evidence that drastically changed the framing of the case. The civil case in question is regarding a property that was illegally transferred to Mayberry, one that was under a standing judicial injunction, is the subject of several ongoing lawsuits. Justice Nathaniel Grayson stated the following in the injunction, the entirety of which is linked here. The injunction is still in place. Princess Elena is still denied the access and usage of her powers as mayor. Any transfer, sale, or divestment of the property is denied at this time. Property ownership on behalf of the county is definitively power of being the mayor. The standing order of the DOJ. Verdict delivered by Ma also contained the following logical arguments. The remaining issue here is the failure to deliver the search warrant in a timely manner. In the motion, the defense admitted fault and will not be contesting this portion of the case. Viewing this evidence, the search warrant does not request for a delayed notice. The warrant was executed on the 14th of July. Nothing in evidence contested. This was delivered. Well, hold on. Who requested the summary judgment? Summary judgment. Did we request summary judgment? Angel did. Due to external communication from the government surrounding the ACR, it was not clear when the DOJ would finally decide to post it on the docket. Given that the ACR has still not been posted, but the case is imminent, my hand is forced to post this motion now. Understanding the DOJ has delayed another action against it in their convenience, I will note this for the future and add it to the ACR. You're clearly too comfortable dismissing proper legal action against you when it's in your favor. Motion for summary judgment. The LSPD acknowledges and understands their responsibility in failing to properly notify the plaintiff, as is legislatively required. We do not contest that this occurred and understand that judgment may be made against the organization as a result. We maintain that any damages caused to the property were entirely reasonable and legal as a search and seizure warrant was upheld. Damage to the property can and will occur when they're executed. We maintain that any legal fees values being claimed or fabricated and fees awarded should be reasonable and demonstratable to all parties in a transparent manner. Injunction. Was that made aware? Injunction. H2. As if not. Wait. Honestly, I think it'd be very funny and interesting to not pay it out and see if Mayberry has standing. Like, yes, on the basis that the order was to pay Mayberry out, but also can the additional information of Mayberry not being the owner be used? I don't know. It's interesting. I think it'd be very interesting. The thing is, there is a judicial appeal. I think we post and let them know. SPD. It doesn't indicate when. So it states, considering both points, the court rules as follows. For the punitive damages sought, the court believes asking for $600,000 is excessive. Given the arguments provided, we're lowering the award down to $350,000 for failure to deliver the warrant in a timely manner. For legal fees, the fees accrued from legal services is a choice made by the plaintiff. Unless circumstances are provided to the court, this will typically not be awarded much, if at all. However, given the issues raised in the response or by the plaintiff's counsel, we'll award $15,000 in legal fees for this case. The one count attempt against Counselor Angel, the court is only requiring Miss Angel to submit written apology. Only to now judge, is it pronounced Lov? L-O-V-F? And Magistrate McMove for the comment made towards them on the docket. And then adding Maxwell, since you were listed here and are a current member of the LSPD, please let the courts know when the payment has been handled. There's no... Oh my god. Wait. This is actually... This is interesting. That ruling was made September 14th. How long ago was September 14th? 58 days. We are 28 days out of statute of limitations, right? They didn't sue. Will we be forced to pay? To be clear, I don't think this is legally sound. But I'm trying to make a parallel to the... Because this really is not much different than the grant stuff. You know how we were like looking at things being out of statute of limitations, and the running theory is that, well, they still haven't followed through with this, therefore the crime is still being committed. What is the actual crime? MDT. Hold on. I'm not getting back in game because I do have to go, but charges. There's fraud, which is wrongfully deceits intending to receive financial or personal gain, but then there is embezzlement, which is every person who commits embezzlement who, being entrusted with money, property, or assets belonging to a business, organization, or government entity, knowingly converts, misuses, or diverts said funds or assets for personal, unauthorized, or criminal purposes. Every person found guilty of this charge will be held accountable for the full repayment of the amount embezzled. But what's the actual crime here? Converts, misuses, or diverts said funds or assets for personal, unauthorized, or criminal purposes. That could be so vague. Every person who commits embezzlement who, being entrusted with money, property, or assets belonging to a business, organization, or government entity, knowingly converts, misuses, or diverts said funds or assets for personal, unauthorized, or criminal purposes. Holy fuck. That is actually... I'm thinking of like hypothetical. Yeah, exactly. So there's no time frame. So it's not necessarily a violation of a court order. Asterisk. It is on the basis that we haven't paid, but there's no time frame to pay. So like realistically, by it not being paid at the same time that the order was made, you'd be in violation of that. Does that make sense? But again, listen to the embezzlement charge. Every person who commits embezzlement who, being entrusted with money, property, or assets belonging to a business, organization, or government entity, knowingly converts, misuses, or diverts said funds or assets for personal, unauthorized, or criminal purposes. The criminal purposes aspect is very interesting. Mm. Yeah, that's absolutely going to be interesting. Um, it's not legally sound, but I think what I'm trying to say is if we argue the time portion, the question becomes, in this case, is it, gosh, how is it determined for violation of a court order? Willful disobedience of the terms written in a court order to include a sentence imposed on a citizen, protective and restraining orders, contempt of court, acts disobediently or disrespectfully towards the court or disrupts judicial proceedings, and time and fine is at judicial discretion. Willful disobedience of it's interesting. Willful disobedience of the terms written in a court order. Does that only occur once in the moment, or is it an ongoing thing? Court order says do something, you don't do it. Is it one and done? They don't rule that way. Would they say reckless evading gets stacked for every reckless instance in like a pursuit? You know, those are two very different things. I'm just trying to figure out where the like continuation or separation of a charge exists. Willful disobedience. The terms written. Considering Maxwell is specifically like the one messaged or like added, yeah, I do think it would fall on Maxwell, which obviously we don't want to happen. Anyways, I have to dip. NoPixel has root.com. It is sunny outside, but it is certainly fucking freezing. All right, chat. I'm gonna get y'all sent off to Glitter, who plays Maxwell. So thank y'all so much for all love support. I appreciate it. Thank y'all for the follows, hosts, raids, bits, donation subs, gift subs, free subs. I say this each and every time. I genuinely cannot have asked a better community to be built around this channel. So thank y'all for being absolutely amazing. Y'all know the spiel. Drop me a follow on Twitch, Twitter, and then join the Discord. Discord.gg/Curvyelephant. And Curvyelephant on all the other socials. I appreciate y'all.